Good afternoon and welcome to um, Digital Transformation Thursdays. So today, let me see. Okay, oh my God, we've got so many attendees. We've got about 400, 374, about nearing 400 people on the Zoom call. And we only have, our account can only handle 500 today. So those of you who cannot log in, for those who cannot log in, this will also be streamed live on the Dicini Law Facebook page. That's facebook.com/Dicini Law. There's also also a live stream on the Digital Transformation Thursdays webpage, which is on dtt.ph/FB Live. So that should be up as well. So we're very happy, actually, to be honest, quite shocked at the response, given the number of registrants that we got for today's event. There were over 1,000, somewhere in the vicinity of 1,200, 1,300 registrants. An overwhelming response, and I think testament to the interest not only in the subject matter but also in the expertise of the speakers that we've assembled today. And so we're really looking forward to their presentations. Our first speaker is Justice Maria Rowena Modesto San Pedro, or Justice Rona San Pedro. She's a graduate from, she's an Associate Justice of the Court of Tax Appeals. So you may find that a bit disconcerting. Why is a Justice of the Court of Tax Appeals talking about cybercrime? Actually, I met Justice Rona many years ago. We were providing training for judges at the Philippine Judicial Academy. And I remember the first presentation that she gave, that I saw her give, was on the anti-photo video voyeurism law. That is a 30-minute presentation on a law that only contains 2 or 3 sections. So myself, if you ask me to talk about that law, I would have only taken only 5 minutes and then I would have stopped. But she put together a 30-minute talk, which showed not only an interesting with different ways of looking at the law, but it was also the way that she did it. It wasn't that she gave a lot of good examples. She drew from many experiences, looked at the subject matter from different perspectives, but also she did something. She gave the law a nickname. She called it the Boso Boso law. So ever since then, I've been calling it the Boso Boso law. I'm not sure if she's the only one who did that, but ever since then, in my mind, when I think photo voyeurism, I think Boso Boso law. But the other thing that she did was, and because she's a judge training other judges, she was a judge back then, a regional trial court judge, was she got off the podium and she started walking among the judges who are her brothers and sisters in the judiciary, and started talking to them at that level. And she connected to them at a very interesting level, and really highlights one of the importance of having judges, trained judges. It's more of a brotherhood, as it were, a sisterhood of peers. And I think that's one of the strongest, best things that I think PhilJA has, and certainly Justice Rona is a credit to PhilJA. She's a graduate of the UP College of Law, and she also finished her master's program in Ateneo for intellectual property. She was a member of the technical working group that drafted the rule on cybercrime warrants and related issuances. And therefore, she's in a very unique position to talk about the rule on cybercrime warrants, which is her assigned topic today. In fact, one of her, and you can tell that rule was really made by judges, because you could see in the back where the standard forms are there. And this is one of the things that I'm pretty sure Justice Rona was was behind that. If not, she probably drafted many of those forms that are in use now, because she understands that this is what judges need, right? She's also a member of the Supreme Court Committee on Commercial Courts. She was a judge at in Pasig City Municipal Metropolitan Trial Court, and later Regional Trial Court. And she is a professional lecturer at the Philippine Judicial Academy, and also a professorial lecturer at the Ateneo law school. So I'd like to welcome Justice San Pedro. Justice?
JJ, thank you for that wonderful introduction. But let me correct you, ha, hindi pa ako nakatapos ng master's sa IP sa Ateneo.
Oh, I'm
because
sorry.
Every time I attend my classes, the professor should say, nahihiya sila, ba't daw ako nandun? So,
actually, I was going to say that because you've actually given presentations in intellectual property in behalf of, meaning in events organized by the World Intellectual Property Organization.
Yeah, I was part of the first ever board of advisors of WIPO.
That's right. That's right. So if I were teaching there as well, I would say we're not worthy.
But I intend to. It's interesting. And thank you, JJ, for inviting me.
Okay, Justice. So if you can start up your slides. Thank you, Justice.
Okay, I'll try to see this. No. Is it showing now?
Yes, Justice.
Yes. We'll just
slideshow.
Yes. I'm having a difficult time because this is up here. They will not anymore believe me that I'm involved in cybercrime.
Yeah. On the left side, it says play from the start, I think.
Yes, but the black thing there is blocking it. Okay.
There you
play
go.
from the start.
There you go. All right.
Let me start this by giving you a background. Yes, I met JJ a few years back, but when we started, when the law started, we said we need an expert, and that of course was JJ. So to let us begin this discussion on cybercrime, let me give you this first question. How many internet users in the world do you think there are as of June 2020? JJ, do you think you can answer that?
Absolutely not. I'll say, okay, I'll guess 2 billion.
Yes. And the guess is?
2 billion.
2 billion, let's see. It's 4.8 billion actually. So you can imagine 4.8 billion internet users around the world as of last month. No? This is 62% of the world population. 62% are internet users. And you see from the graph here that a big number of that chunk comes from Asia. It interested me to see that North America is a very low 327 billion only. So makikita natin no, that we from Asia are really big internet users. How about mobile phones, Jay? How many mobile phones do you think there are in the world already?
Mobile phones. It has to be equal to the, I don't even know what global population is. I'm sorry, but I'll say 8 billion. I'll say 8 billion.
Let's say 8 billion. Let's look. Quite near, 6 billion, lesser.
Okay.
And of that, 3.5 billion are smartphones. No? How many Facebook users are there?
In the Philippines, if the population of the Philippines is 100 million, there are 200 million Facebook users in the Philippines. Okay, it's 1.84 billion. There you go.
Look at that. That's a big figure. And of these, number one in Asia would be India with 251 million users, Indonesia, and we're only number 3. Akala ko rin dati na at malaki yung difference between Indonesia and Philippines.
But they're twice our population.
Yes,
so
but
in terms of
population. But we are heavy Facebook users, heavy internet users. And that would give us a background why there really should be much emphasis and concern about cybercrime. Now this one, JJ earlier said that I'd go down from the podium and go to the judges. Sayang nga ngayon because I cannot see the audience face to face. I tell them, don't be scared. This is a safe venue. Manghula lang tayo. So sa hulaan, what do you think is the number one cybercrime in the USA?
Number one, I want to say scams, but I'm probably wrong.
And it's computer fraud.
Okay.
Do you think that is the same in the Philippines? That this is one of our top crimes in the Philippines?
So interestingly enough, we have Agent Senora later, and he will be discussing. He will be discussing that.
Not to preempt him, no. But here I'll give you the top 3 in the Philippines, and I think medyo obvious that number 1 is online libel. And interestingly enough, also the bulk of the online libel cases are not really against the press. These are private messages on Facebook mostly. Number two is online scam, which is swindling and estafa. Kasama dito yung, we called it the love scam. No? Love scam was so prevalent with NBI, yung kwento nila sa akin. And they usually target middle-aged women who are lonely, tapos ginagamit yung kalungkutan nila para i-scam sila. And they target the pensions of these lonely women. So ingat lang, no? Yung mga middle-aged. And the third one, yung sinabi mo nga na ang tawag ko ay boso-bosolo, the anti-photo and video voyeurism. So those are the top 3 cybercrimes now in the Philippines. Let me share with you the jurisdiction of cybercrime courts, which deviates a bit from what we are used to. Number one, local courts have jurisdiction over all Filipino citizens, regardless of the place of commission. So, basta Filipino citizen, kahit sa Japan niya kinumit yung cybercrime, the courts here will have jurisdiction. Another one would be where any of the elements were committed within the Philippines or committed with the use of any computer system partly situated within the Philippines. And lastly, that the commission causes damage to a natural or juridical person who at the time of the offense was committed was in the Philippines. So it's not anymore territorial, no? It's not anymore where the crime was committed, but it gives also leeway for jurisdiction to be taken if it was committed by a Filipino citizen or caused damage to a Filipino citizen, to someone who was at the time the crime was committed in the Philippines. Now, I'm sure JJ, who is the Decini case, known for that, can tell us what are the offenses punishable by our RA 10175. Yung tinawag namin the CIA, which are CIA offenses, are against the confidentiality, integrity, and availability of computers and systems. So dito papasok yung illegal access, illegal interception, data interference, misuse of devices, cyber squatting. I would dare guess that at this point, we have very few CIA cases as yet. And then we have computer-related offenses, which are forgery, fraud, and computer-related identity theft. This would be on the rise. We also have content-related offenses, largely cybersex, child pornography, and libel. And then what we call the Section 6 offenses are those regular offenses under RPC, which are committed through the use of computers or ICT. An example would be threats and coercion. Now, so we had the 2012 law, and then, of course, it was brought before the Supreme Court and some sections were found unconstitutional. But when that was already, cases coming out from that law were being brought to court, the judges found themselves not ready to handle these cases. So I was a member, and I still am a member of the Philippine Judicial Academy, which is very responsive to the needs of judges. So in the academy, I was a member of the Commercial Law Department. They said, let's come up with training for judges. This was way back in 2016. And what happened then was they came up with an original syllabus. And I said, and they assigned me something on handling of evidence for computer cybercrime cases. And I said, usually I take it. I take these assignments immediately. But then I said, no. No matter how I think I am computer savvy, I cannot do this. I'm not ready. And then, so we decided, let's put up a roundtable discussion. And JJ was with us. JJ, do you remember this way back in 2016?
Electoral RTD. Ah, yes, that's right. That's right. I'm sorry.
The beginning. This is the birth of the training of judges on cybercrime. So I said, let's. We're not ready. Let's have JJ on board to be the moderator of that roundtable discussion with me. We were fortunate to have Thomas Doherty, who was the regional head of cybercrime of the U.S. U.S. Embassy in the region, and then. I don't know, no, but we found that it was important to have a multi-sectoral roundtable discussion. So we brought on board some representatives from the NBI, the DOJ, and the PNP. And that was a very interesting discussion, if you remember, JJ, no? So
Yes, yes.
what came out for that was there was a need for clear rules on how to proceed in obtaining digital evidence, no, and procedure for cybercrime cases, especially search and seizure, because there was what we call preservation of traffic data. The NBI and PNP could do that on their own, but nagsumbong sila sa amin, no? Hindi naman ho ini-ignore yung aming mga requests from the telcos. Sabi namin, bakit? Kasi wala nang clear rules on how to go about it. So it became evident that their protocol for search and seizure of computer data was lacking. And this was largely something that was new to judges, not only to judges, but also to the NBI and the PNP. And of course, the subjects of that, they could easily resist and deny, saying na walang clear rules. So we said, okay, from that, we coordinated, we asked the PNP and the NBI what their problems were, and having those in mind, that's where we had the start of coming up with the rules of procedure for cybercrime. And then, so in August 2018, 2 years after, because this was a work in progress, finally, we were able to come up with this rule on cybercrime warrants, and this is how it looks like. No, we distributed this. The technical working group that worked on this, because I was also a member of the Supreme Court Subcommittee on Commercial Courts, the members of the TWG, a majority of those were all present in that roundtable discussion. So they knew, no, where to start. And then we finally came up with 8 sections for this rule on cybercrime warrants, which would be the general preliminary provisions, general provisions containing definitions. We have preservation of computer data, disclosure of computer data, which proved really relevant to the NBI and PNP, and then interception and search, seizure, and examination of computer data, which is within the domain of courts, and custody, and finally destruction of computer data. Let me tell you that there are 8 courts now with national jurisdiction in issuing warrants. We patterned this after what we had in the IP rules also, which gave 4 courts national jurisdiction. So because of that, we launched the cybercrime training for judges. And this is what I'd like to share with the audience here with us now, that the Philippine Judicial Academy and the Supreme Court, they're really doing their best. We're exerting our best efforts to bring cybercrime training for judges. These are more or less the topics we have in our training for judges. First, we have the rule on cybercrime warrants to give them a briefer, together with a briefer also on the Budapest Convention and its relevance to our warrants. This, we are fortunate to have Supreme Court Justice Estela Perlas Bernabe and Court of Appeals Justice Apolinario Bruselas Jr. taking turns in taking this topic. And then we have the cybercrime basics and the cybercrime law. Of course, JJ takes that on together with former IP head Ricardo Blancaflor. And then we've invited experts from the US to give us an overview on digital evidence. Ito patok na patok to sa judges because this OV Carol, he'll let the judges get out their cell phones, no? And then sasabihin nila, and then he'll run them through, going through their apps to show them that he can actually tell them where they were on this particular date at this particular time. Ako, nagulat ako that it can even, like if you were in an outlet in Spain, it can even tell you which store you entered, no? So yung mga lalaki dun sa audience medyo natakot, no? And then we have privacy in digital media, which Supreme Court Justice Marvic Leonen explains on, giving, of course, a briefer on how to balance and make sure that the privacy rights are always protected. Judge Nelda Montesa, who's very famous now because of her decision in the Maria Ressa case, Rappler case, takes on preservation, disclosure, and interception of digital data. I lecture on warrants to search, seize, and examine. A few of my slides I will share with you later. And then Judge Elma Wagan of Pasay explains on custody and destruction of computer data. Our training will not be complete without the the participation of our guests from the PNP. For here, we have Major June Aprezado and Levi Lozada. They teach us about how they go about analyzing the computer data, which is forwarded to them after these are seized. So all in all, maganda yung training namin for judges. And I hope that we can get feedback also from the practitioners as to how their cybercrime cases are being heard by the courts. Now, as I said, I will give you a very quick rundown on search and seizure. Search warrants to search, seize, and examine. What are the commonalities with the ordinary search warrants with this type of warrant? Also, they can only cover one crime. And of course, the same would be also the requirements of particularity, particularly on the items and the places to be searched. The difference now is, unlike ordinary search warrants, where yung items to be seized are tangible, magsiseize ka ng fake DVD, kukunin mo yung DVD, kukunin mo yung fake Maggie Savor. Dito, not only tangible items are the subject of the warrants, but also non-tangible. That's why, because of this reason, we also have on-site and or off-site searches, physical versus non-tangible search. So those are the differences. As I said, what's the subject of a warrant to seize, search, seize, and examine? Computer data, which you know that, no? These are human-generated, computer-generated, or a hybrid. Now, what are these computer data? Pwedeng contraband itself, the computer is stolen. It's a repository of data that is contraband. Pwedeng fruits of the crime, instrumentality of the offense, or even evidence of a crime. So when we talk about computer data, it can be spreadsheet showing even illegal drug transactions, or a letter used in fraud, or log files, and also files showing when a computer and when a website was accessed. Now, like ordinary search warrants, only law enforcement authorities may apply for these. These parang review ng search warrants, what do this application contain? Of course, what the one crime involved, a particular description of the computer data sought, etc. Now, what additional information? Again, we go to what's the difference. Here, we ask for an explanation of the search and seizure strategy. Because unlike ordinary searches, hindi yung pupunta na lang dun sa site and then search and seize, no? You have to have an explanation. I'll expound on that later. And also a projection of whether the search will be on-site or off-site. Of course, a listing of the items to be searched, seized, and examined, and that these were observed to be at the search site. Another important matter that should be in the application is the projected time frame. Now we know the probable cause requirement. Same as ordinary rin, yung description of the place, it's best to include the sketch and the photographs. I want this, no? Now, I have a query. Is a warrant seeking to search, seize, and examine, in quotation, all records of a computer valid? I'm sorry, JJ, you are my only audience that I can interact with, so I will have you warrant a guess to this query.
No. So Justice, you ask a question, and then we will see people answer. I want you to know that I'm seeing that we have people from Davao City, people from Butuan, Pangasinan, Tarlac, from all over the place. So you ask this. What's your question? Is warrant seeking to search?
Seek and examine, to search, seize, and examine all records in quotation of a computer valid.
All right. There's an answer here from Leanne Torato. Her answer is no. Catherine Mesuelo says no. Christian Maris Valdez says no. Mukhang di ano po is no. May nag-yes.
Yes, no, lahat sila no. And of course, that is correct. No? It's overbroad and unreasonable. Because we are new to this, we follow the DOJ advice that says you begin with an all records description and then you use qualifying or limiting language, stating, of course, all records of JJ Decini from the period of June to July 2020, and then include explicit examples of records to be searched. No? So thanks for that, JJ, for facilitating. Another query, can the search include deleted, encrypted, or password-protected files on a storage medium found at the search location? Can
Okay,
you
I'll wait for the
include that in
answers.
your application? And
Puro
can
yes. Okay, let me see the names. Trish, ang dami, mabilis. Roel Campolo, Joseph Caneva, John Marie Paragas, Francia Osorio, Edrenal, Caliaga, Panganiban. Puro yes.
Puro yes. Okay.
Yes.
And I'd like to say, magaling sa Davao, I ensure you that the Philippine Judicial Academy has gone nationwide to teach all the judges so far. We're doing our second set na siguro. No? Yes, you're all correct. It's reasonable to believe kasi that the object of the search will of course be tinatago. It can be found therein. Tinago nila. So yes, the search can include those that are password protected. Now, when can off-site search be conducted? If it's not possible to do the search on-site, no. But the important thing is if an off-site search is to be conducted, the ones executing the warrant should ensure that a forensic image must have been made. This is an image copy, no? And they have to put also the reasons in their return where an off-site search must be given. Now, let's talk about why. Why do we go to an off-site search? The measures of computer data are terabyte, petabyte, exabyte. And then the last is ito, no? Equivalent to 166 trillion bytes, miles, or 266 times around the sun. Yung mga nagpa-floppy disk ng 80s, if you remember there was a big one para ganyan size, there is a smaller one. Those floppy disks of the 80s only contain 20 pages of text. A gigabyte is equivalent to 1,000 feet high stack of paper. So we envision that already. 1 terabyte, usually, marami tayo niyan, up to 1 terabyte external hard drive. JJ, anong pinakamarami mong external hard drive?
Ayoko umamin. 8 terabyte.
So, sabihin lang natin 1 terabyte. 1 terabyte can contain all the documents in all file cabinets in a big building. So can you imagine yung laman ng 1 terabyte na yun? While 8 zettabytes was created in 2015. That's my latest. So can you imagine if you seize my laptop, that's the seizure already of all the documents in my office and in my house. No? And then, so it's due to the immense storage capacity that the computer search can be unreasonable because of overbreadth. Parang hindi kagaya nung search na physical, in one go, makikita mo yung laman ng pupuntahan mo, pwede mong kunin. Dito, because it's computer data, it can be unreasonable to expect that in one search incident, you can get everything. So since computers store large volumes of information, it will be impractical to expect the enforcers to get everything during its implementation. No? So, and also, sometimes passwords prevent them from conducting the search on site. So they have to extract this outside, no, in their labs. Okay. Now, what must be done? I said, of course, make sure there's a forensic image. Computer peripherals, you also need not just, you get everything so that a match, when you do it off-site, magmamatch yung equipment. No? Now, another query. In the course of a valid search involving computer fraud, so the search warrant was for one crime, no? Computer fraud. The police discovered pornography in the respondent's laptop. Can he still continue to search for child pornography? Jay?
No, meron. Sorry, Justice. I'm looking at the answers. There's, merong, hati po ang ating audiences. Ang audience. Some are saying no, some are saying yes.
Why yes and why no? Are there explanations?
Sabi nung isa, yes, kasi part daw of a valid search.
Okay.
Yung isa po, sabi niya, plain view doctrine. That's Nyerson Tualia.
Yeah.
Made in the course of a valid search from Ray Pulikay.
Meron ba nagsabing no?
Meron nagsabi, each warrant is for each instance. Again, Renato, I think, madami na po nag-no. Madami nag-no.
Okay.
Sabi, the search warrant is for fraud only. Oh,
so the answer is no. No. Another warrant must be applied for the crime of child pornography. So we have to remember one crime per warrant. Now, I understand those who say plain view doctrine, di ba? But we've looked at cases in the US where tinapon, no, they were not admitted in evidence Why? Well, it depends, no? Some jurisdictions say no, because you have to apply immediately for another. But some says, if you abandon the original search premise, which was for computer fraud, and went on the path of child pornography, then that's a no-no. Kasi inabandon mo na pumunta ka na dito. But this is a general rule now, no? Best to be safe, one crime per warrant. Okay. What activities are allowed when you're implementing the warrant to seize? Interception of communications and computer data can be done, provided these are reasonably related to the subject matter of the warrant. And then again, you have to explain the reasons in the initial report and must be fully disclosed. Now, we also place this cooperation from persons on site. The PNP and NBI can order anybody on site who knows about itong two things, the functioning of the computer system and measures to preserve and protect the computer data, to provide necessary information to enable a successful search seizure operation. We envision here, example, you're in an office and there's an IT department, then the law enforcement authorities can ask for their cooperation. Now, if ikaw naman yung nakuhanan ng computer data, what is your remedy if you think that it's an unlawful seizure? Of course, you file a motion for the return of the computer system, but if I were the judge, I'd make sure first that there was a forensic image already that was made. You can say that no lawful ground exists to withhold the return to you as the owner, and it's necessary for you to recover possession. Let's say, yung thesis ng anak mo nandun, or yung tax documents mo nandun, then yes, it can be done. Maybe the other speakers will explain more about this forensic image and why it's really secure because of the hash values. No? Now, cooperations, we did this. What's the remedy? And then two-stage search, again, the imaging, which is you copy everything on site, but the analysis can be done later on in the lab. Okay, query. This is a nice query, no? A policeman assigned to a mall responds to a call for assistance from department store security guards because a suspect is being held, complained of taking unauthorized video of women in the dressing room. So the policeman arrests the man and takes possession of the cellular phone. Now, yung women, galit na. They want the cellular phone to be opened and examined so that the videos taken of them may be erased and verified to be used as evidence against the suspect. The question now is, can the policeman right there and there search the cell phone which he has taken in his possession?
Grabe, Judge, ha? Itong mga question na to, ako nahihirapan. Kung nagpa-exam ka, babaksak ako. Okay, so I'm looking at, madami po sumasagot. Hati po ang ating audience. Although I think it's leaning towards no.
No.
No. Okay, so they need a warrant now. But sabi, you cannot search, but you can confiscate the phone.
Yes. Okay.
Sabi so, isa, search to incidental to arrest.
Okay.
You can search now, incidental.
Did anyone say what kind of warrant they need? Because in this, this is a lawful. Let's look at the answer na, ha? No, he cannot. He cannot, even if he lawfully confiscated the phone, he cannot open it. He must apply for a warrant to examine computer data. So this is another warrant. The warrant to search, seize, and examine is different from a warrant to examine computer data. And what are the requirements for this new type of warrant? There should have been possession of a computer device. In this case, it was a mobile phone, which was acquired by a lawful warrantless arrest or other lawful means. No? And then a forensic examination of the computer data is needed. There's a probable offense involved, and there's relevance and necessity of the computer data sought for that particular investigation. No? And then you say what were the circumstances surrounding the lawful acquisition of the computer device. So in my query, yun nga, no, he was called upon by the security guards because of the, he was caught in the act of taking video of women in the dressing room. But again, there's a different warrant to examine that is needed. So it has similar provisions as the warrant to search, seize, and examine. I said no that there are 8 courts throughout the Philippines where they can issue warrants enforceable all over, no? And this is because computer data is stored in a network and may be located in multiple locations. Now, can warrants be executed abroad? Yes, these 8 courts can issue warrants which can be enforced outside the Philippines. But I must clarify here, hindi yung court ang mag-execute, no? They should be coursed through the DOJ Office of Cybercrime. Do I still have time, JJ?
Yes, Justice.
This is the going near the end na, no? I'll just share what are the common defenses in cybercrime. Itong ghost in the machine. Ghost in the machine, sasabihin nila, naku, di ko alam ano nangyari. May virus yung computer ko. There was a zombie in a botnet. It was controlled. I had nothing to do with the crime. No, may ghost dyan. May nangyari dyan kamangha-mangha. How would you go against this defense? No? Rebut with evidence that may antivirus software naman yung machine mo, no? And then the examination of your computer will show that there are no known viruses, trojans, or spyware programs found therein. And then let's also use other corroborative evidence, no? Let's say yung crime niya was child porn, and then we look into the computer that there were Google searches for terms relevant to the crime, no? We can also look at similar aliases in email social networking sites. Na he used the same alias. Of course, we always emphasize in our training, don't be limited to cyber data. You also use non-electronic evidence like physical surveillance na will show that he was actually in front of the computer, no, at that time. Another events is what we call the SODI defense, or some other dude did it, no? Sasabihin niya, I'm not the only one with access to my computer. There were other people in my dorm. My roommates had access. I used a wireless router, you know. There could have been somebody who hacked into it. Others had access to the server. How do you rebut that? You show firewall logs. You show remote desktop logs. You show that he only had one account and there was a password set up on his computer, that no way could anyone have entered his computer without knowing that password. You show that the router was locked down. Other activity on the computer indicative of the defendant's use of it before and after incriminating activity. So you look at the time log. Kung yung crime was committed between 3 to 3:30, and you can show that he was using it before 3 and after 3:30, then that's good evidence. No? Again, non-computer evidence, security cameras, office pass keys, recent purchases. No? Another common defense is he was not technically capable. No? Hindi ako marunong yan eh. I have no technical degree or training. So you combined it with make it really confusing. No? Sabihin ka, I don't know what's happening. But you rebut that with evidence showing his educational background, yung work history niya, naging tech support pa siya, testimony from close classmates, co-workers, people who know him, to have working knowledge of how to use the computer. And then you look at purchases even, internet history, to show na, oy, meron naman tong knowledge about how to use the computer. No? And then another one, sabihin niya, I've been framed. No? Malinis naman yan eh, nung sinearch nila. Tapos bigla na lang nandyan yan. Something must have happened in between when that computer was imaged, because I swear it wasn't there. No? The NBI, the PNP is framing me. So how do you rebut that? You look at the time, date stamps on the imaging. I told you about the importance of imaging the file. And then the present log and audit files. You also document. That's why when we, I've had the privilege also of talking to some PNP personnel. It's important that when you go, you photograph and document the whole search operation, yung first respondents. And then you show the chain of custody, much like drugs. And then this is the most important thing that mahihirapan na yung accused to resist, to show that the hash values are the same, no? To prove authenticity of data. And explain, of course, the process of imaging to protect the evidence. These are things that you will have to convince the judge of. But hand in hand with how we're training the judge, they already know how to look for and how to ensure that there was security in the image. We also have that defendant lacked the intent or mens rea. Sabihin niya, hindi ko alam that selling copies of software is illegal. I thought sharing copies of software was okay, no, for IP crimes. You rebut that with evidence na binigyan ka na ng cease and desist notices eh. And then you had in chat logs, you were also participating, and then you had termination or warnings by ISPs, and you also showed na yung sinishare niya is shoddy quality with low prices. So, okay, I stop share. JJ and the audience, I hope that was, I did my part in sharing what I know in cybercrime.
Thank you, Justice. We're very grateful. There will be an open forum later, but looks like you started off that. There's some comments already. Very informative, Justice, from Marco Kunanan. We have people all over the country listening in. There's even somebody from LA.
Wow. JJ, I'll share lang, no? I'll share.
Legazpi Albay.
Oh, I'll share lang, no? I was appointed MTC judge in 2001. Mm-hmm. When I was an MTC judge, I saw that most of the judges, ang daming folders sa harap. What I did, it was really helpful for me. From the beginning of as I sat as a judge, I already had a laptop. I remember my laptop then was medyo, hindi as ganda nitong mga bago nating Mac, no? But my father-in-law, I have to thank him. He, up to this date, no, he's so computer savvy. He gifted me with a set of search engines na nasa CD pa. So from the very beginning, I started my career in the judiciary, trying to be computer savvy, and I think it has helped me. But now, especially now with COVID, I'd like to share also that here in the CTA, we've had successful video conferences. We've had the cooperation of the BIR and the litigants. Ang galing, kasi kahit malayo, can join us. So I hope that this interest in cybercrime and in being computer savvy can be spread more among the litigants, litigators, practitioners.
Thank you, Justice. I just have to say that, so we've been doing this for a couple of weeks. You're the first one to do a Q&A with the audience. So so that's the, I think that's the webinar equivalent of going down to the audience.
Yes.
With your mic, and I know you like to do that. You hand over the mic, and that's always been very effective. I remember David Bragdon commented on that as well, and he actually copied that from you.
Yes.
I don't know if you remember.
Nice.
David Bragdon was formerly the head of the U.S. DOJ Office of Prosecutorial Development Assistance with the U.S. Embassy. Thank you, Justice. I appreciate
everyone.
Thank you. So moving on to our next speaker. Our next speaker is Attorney Angeline Medina. She is a state counsel at the Office of Cybercrime at the Department of Justice. Just for the benefit, for the information of our attendees, the Office of Cybercrime Department of Justice heads or handles international coordination for cybercrime. She's a graduate of San Pedro University in 2015, where she ranked the third in her batch. She is in the DOJ's pool of cybercrime trainers. She was formerly an associate at the Herodia Sushanko Estrella Law Firm, GSE, from 2016 and 2017. And she handles a lot of cybercrime cases, and we're very happy to have Attorney Ange here. Attorney Ange, if you could, I think you need to turn on your video, and I see that you're sharing your slides already.
Yes.
All right, thank you, Attorney Ange. Please take over.
So good afternoon, everyone. As mentioned by Attorney JJ, I am State Counsel Ange Medina of the Department of Justice, Office of Cybercrime, and I am here to share with you some points regarding cybercrime investigation and prosecution in the country. Okay. So it is our objective that after this presentation, the participants will be able to be familiar with the provisions of the Cybercrime Prevention Act of 2012, learn who the competent authorities responsible for the enforcement of the Cybercrime Prevention Act of 2012 are, learn about the Department of Justice Office of Cybercrime and its role in cybercrime investigation and prosecution, and of course, gain practical knowledge on how the government is handling cybercrime investigation during the pandemic. So with that objective, you can see the outline of this presentation. And as you can see, we would also be discussing about advisory opinion number 1, series of 2018 issued by the DOJ Office of Cybercrime. And this advisory opinion is entitled Institution of Cybercrime and Cyber-Related Cases. To give a foundation of this discussion, it's worthy to note about what is the policy of the state in our cybercrime law. So due to the advent of technology, it has become the policy of the state not only to protect and safeguard corporeal and tangible properties, but also to afford the same safeguards to intangible properties from all types of misuse and abuse. So in particular, the state has recognized the necessity to protect and safeguard the confidentiality, integrity, and availability of computer data and computer systems by adopting mechanisms to effectively prevent and combat offenses committed against them by facilitating their detection, investigation, and prosecution at both the domestic and international levels. So in this regard, the Congress passed the first comprehensive law on cybercrime in 2012, and that is the Cybercrime Prevention Act of 2012. So our law, as mentioned earlier at the first part of this webinar, is basically patterned after the Budapest Convention on Cybercrime, which is the first international treaty that seeks to deal with computer crimes and crimes committed over the internet. So our cybercrime law, consistent with the policy of the state to protect intangible properties and to facilitate the investigation of cybercrime, is divided into 3 types of provisions, and which relates also to the 3 aspects of cybercrime investigation and prosecution. So first would be the substantive provisions. Kanina medyo na-discuss na ni Justice yung mga substantive provisions, and these are the provisions that provide for the cybercrime offenses under the law and their respective penalties. So the second type of the provisions in our cybercrime law are the procedural provisions, which equip the law enforcement authorities with technical capacity in order to facilitate the conduct of cybercrime investigations. So the warrants, the preservation order and the warrants that were mentioned earlier by Justice, these are the procedural tools that are being used by our law enforcement authorities, the NBI and the PNP, to facilitate the investigation of cybercrime cases. So lastly, the third type of provisions within the Cybercrime Prevention Act would be the provisions on international cooperation, which seeks to address the transborder nature of cybercrime. When we say why do we need, or why we specifically why should we specifically include the international cooperation mechanisms in the cybercrime law? It is because we know that cybercrime is of transborder nature. So an illustrative example of this would be that a cybercriminal can launch an attack and perpetrate a crime against anyone situated anywhere across the globe, or in a case involving the example is a case of proliferation of child pornographic material in social media. So paano yon? For example, someone who would commit illegal access, hindi necessarily na andito siya sa Philippines. So kahit na yung target niya, the owner of the account, for example, a Facebook account, is here in the Philippines, the perpetrator of the crime can be somewhere else across the globe. So in that regard, we can see the transborder nature of cybercrime, and also, for example, in the case of proliferation of child pornographic materials in social media. So the PNP or the NBI, for example, they have an intelligence, or there was a report that a certain John Doe was proliferating or distributing child pornographic materials through Facebook. So in this scenario, for us to learn who this John Doe is, or to have the subscriber information of this perpetrator, we need to coordinate with Facebook or get the computer data or the records pertaining to this John Doe account from Facebook. And Facebook is a foreign company, and Facebook is a foreign company situated in the US. So from there, you see the transborder nature na while we are investigating a crime here in the Philippines, there is an essential need for international cooperation, because maybe the perpetrator of the crime is nasa ibang bansa, o kaya the evidence, the electronic evidence that you need in furthering the cybercrime investigation is at the hands of someone in another jurisdiction. So those are just illustrative examples, but syempre there are a lot of scenarios that can explain the transborder nature of cybercrime also. And thus, because of that, the need to foster effective and efficient international cooperation among neighboring states comes into play. All right. So, nadaanan na to kanina ni Justice, but let's just read them. Basically, the offenses under the substantive provisions of the cybercrime law, they are divided into 3 categories of cybercrime offenses. The offenses against the confidentiality, integrity, and availability of computer data. So these offenses, yung CIA offenses, these are the offenses related to cybersecurity, and the target of the offense would be negatively affects the confidentiality, integrity, and availability of computer data, or what we know as the CIA triad. Put simply, the private information should stay private. It should be confidential. It should not be changed without the permission of the owner, and the data, services, and systems should be accessible to the owner at all times. So that's on the integrity and availability part. It is also worthy to note that the substantive provisions of the cybercrime law uses technology neutral language, so that the substantive criminal law offenses may be applied to both current and future technologies. Kung babasahin nyo yung ating cybercrime law, makikita nyo doon, like for example, illegal access. It was written in a technology neutral way that that even if in the future there would be other technologies that would emerge na magiging iba yung way how the illegal access was committed, but papasok pa din siya as among one of the offenses in the cybercrime law. Okay, so we also have computer-related offenses, computer-related identity theft, computer-related fraud, computer-related forgery, and content-related offenses, cybersex, online child abuse, child pornography, and cyber libel. So this was also discussed earlier when the commission of traditional crimes or crimes punishable under the revised penal code at yung under special penal laws, when it was committed through by or with the use of information and communications technology, the penalty is 1 degree higher. All right, so now let's go with discussion. I saw the list of our participants, and most of them are private practitioners, right, Attorney JJ? Most of them are
mix oren. There are a lot of prosecutors. We also have judges.
Okay. So legal practitioners. All right. So It's worthy to note that we know sino ba yung law enforcement authority. If there is a cybercrime incident, kanino ba lalapit yung mga victims, or if you're a lawyer, kanino mo ilalapit yung kaso ng iyong kliyente. So under the cybercrime law, it is clear that the law enforcement authorities that are responsible for the efficient enforcement of the provisions of the cybercrime law are the NBI and the National Bureau of Investigation and the Philippine National Police. And they were also instructed to organize their cybercrime unit and manned by special investigators to exclusively handle cases involving violations of this act. So in this regard, the NBI created their cybercrime division, and also ang PNP, they created their anti-cybercrime group. So kung maririnig nyo from the news kapag nakakarinig tayo ng cybercrime operations, lagi ang nababanggit, the operation was led by the PNP Anti-Cybercrime Group and the NBI Cybercrime Division, because these are the special units that are tasked to handle cybercrime and cyber-related cases. But in relation to the discussion on who the law enforcement authorities are, let us discuss the advisory opinion number 1 series of 2018 that was promulgated by the Department of Justice Office of Cybercrime and signed by SOJ Guevara in 2018. So this advisory opinion was promulgated following different interpretations and numerous queries received by the Office of Cybercrime regarding whether or not it's a necessary requirement to first file a report, or for the PNP ACG and the NBI CCT to undertake an investigation of a cybercrime incident before the victim can file a case before the prosecution service. Kasi kung mapapansin nyo, the last sentence of Section 10 of RA 10175, nakalagay doon that the special units manned by the special investigators are to exclusively handle cases involving violations of this act. So there were interpretations that you cannot directly file a case before the National Prosecution Service or file the case before the prosecutor's office without going through an investigation sa PNP and NBI cybercrime units. So we heard also that there were cases that were dismissed or mga filing daw na hindi tinatanggap. So because of this, the Office of Cybercrime issued the advisory opinion which says that prior investigation or assistance of law enforcement authorities ng PNP and NBI in case build-up is not necessary in filing of complaints for cybercrime and cyber-related cases, such as when the identity and location of the perpetrator have already been identified and there is enough evidence to prove the presence of all the elements of the offense. So hindi necessary. Hindi kailangang dumaan muna sa NBI and PNP bago ka makapag-file sa prosecutor's office. However, if there is a need for you to use the procedural tools if there is for you to need the procedural tools that are available under the rule on cybercrime warrants, which are the same that are under the procedural tools of the Cybercrime Prevention Act, doon kailangan mong dumaan sa PNP at sa NBI because, as discussed earlier by Justice San Pedro, it is only these law enforcement authorities who can use or apply for these warrants or procedural tools. So kung nakikita mo na yung case mo medyo mahina pa, it's not yet airtight, you need to get more electronic evidence, you need to know who the perpetrator of the crime is, and by doing so, you need to ask electronic service provider to provide subscriber information to further the case that you are building. Dadaan ka sa PNP at sa NBI because sila lang yung they are the competent authorities to apply for these warrants. Okay. The next part of the advisory opinion is that it answers the question si ACG at si CCD lang ba? Sila lang ang merong right to, they have the exclusive right to handle cybercrime and cyber-related cases. Na ibig sabihin, you can't file a cyber-related case to another unit of the PNP or the NBI. So the answer of the advisory opinion of the DOJ says that no, and that the phrase to exclusively handle cases involving violations of the cybercrime law does not confer the ACG and the CCD the sole authority and competence to investigate cases involving 10175. So mapapansin nyo sa news, like for example, it's a cyber-related case or it's an online child pornography case. So cybercrime, cyber-related case, but the law enforcement authority that has been investigating and doing operations in relation to this crime is not the ACG or not the CCD, but the Women and Children Protection Center of the PNP. Okay, if it's an online human trafficking case na ginamitan ng information and communications technology, ang naghahawak sa side ng NBI would be the Human Trafficking Division, Anti-Human Trafficking Division. So it's not necessarily na cyber-related case is that ang hahawak is the ACG and the CCP, because of course if there is another unit that's competent to handle such case, like for example online child pornography cases, then it is handled by a different unit of the PNP. So rather than the exclusivity pertains na ACG lang at CCD yung maghahawak, the exclusivity phrase provides a limitation on the types of cases that may be handled by the CCD and the PNP ACG. Okay, now let's go further on what is our office, the Department of Justice Office of Cybercrime, and what can we do, or what is our mandate, and how can we help you in cybercrime investigation and cybercrime prosecution. So the international cooperation mechanism of our cybercrime law is lodged within the Department of Justice Office of Cybercrime, which is designated as central authority under the cybercrime law for all matters relating to international mutual assistance and extradition as far as cybercrime and cyber-related case is concerned. So it is also competent authority for all requests for assistance for investigation or proceedings concerning cybercrime and cyber-related offenses. So I'll give you an illustrative example. So for example, Senior Agent Senora, who will be with us later, he's investigating cybercrime involving a phishing email. So meron siyang email address, meron siyang Facebook account na ginamit din at some point in the phishing email, and kailangan niyang makuha yung information regarding those accounts. So it is the Department of Justice as central authority, or is lodged with the international mutual assistance and international cooperation powers in cybercrime and cyber-related cases. Siya yung makikipag-coordinate, siya yung magiging bridge between the law enforcement authority, the PNP and the NBI here in the Philippines, and the competent authority doon sa ibang bansa in getting this necessary electronic evidence. So na-mention din kanina ni Justice San Pedro, like for example, na meron tayong may na-issue na warrant, and this warrant is to be served to a foreign corporation, like for example, yung ating mga electronic communications service providers like Facebook, like Gmail, YouTube, and Instagram. Kailangan natin silang servan nung in-issue na warrant. This, under the rule on cybercrime warrant, should be coursed through the Department of Justice Office of Cybercrime. Also, we are also a competent authority for all requests for assistance for investigations and or proceedings concerning cybercrime and cyber-related case. And ang nangyayari lang, like for example, merong pupunta sa amin sa office and they would report an cybercrime incident, we would do initial investigation, but at the end of the day, if it really merits further investigation, we refer it to the NBI and the PNP, who are the law enforcement authorities under the cybercrime law. So it is the NBI and the PNP pa din who ang magkakandak nung cybercrime investigation. But the DOJ OOC would assist them, like for example, in getting electronic evidence from abroad or giving legal advice in relation to the cybercrime incident. Okay, so we are also the 24/7 point of contact in line with Article 35 of the Budapest Convention. So ang 24/7 point of contact, para siyang 24 by it is a mechanism under the Budapest Convention for the member countries to provide immediate assistance for the purpose of cybercrime investigations and proceedings. So we can provide provision of technical advice to our foreign counterparts. We can assist them for preservation of computer data. We can assist them with collection of evidence and giving provision of legal information and the location of suspects, and vice versa. Kapag kailangan natin ng tulong ng ibang bansa, the law enforcement authorities here in the Philippines will course through the request for immediate assistance through the DOJ and papunta sa ating foreign counterparts sa ibang bansa. Okay, so what would be the advice that kapag may lumalapit sa aming clients regarding cybercrime and cyber-related cases, what are the advice na nabibigay namin sa kanila? So basically, this would cover what type of offenses can be filed, saang law enforcement authority sila kailangang lumapit. Should it be with the ACG? Should it be with the CCD or what special unit? Or should it be with the NPC kung sakaling it's a data privacy violation? And also we can give them practical tips on how to reduce the financial impacts of cybercrime and what are the possible pieces of evidence needed in proving the existence of a cybercrime. Just a point of, it's not necessarily na involve lang ang Office of Cybercrime kapag ang pinag-uusapang crime is a cybercrime or cyber-related offense. As there are also instances that pwedeng yung request for evidence is coursed through the Department of Justice Office of Cybercrime kapag ang kailangan nating evidence or ang hinihingi natin from our foreign counterparts would be electronic evidence or electronic or digital evidence. So kahit na traditional crime yan ang ine-investigate ng law enforcement authorities, but we are dealing with the digital electronic evidence. The Office of Cybercrime can assist the law enforcement authority as to the proper handling or provision of technical advice on in relation to this electronic evidence. So this would be the last part of my presentation. What are the government responses in this time of COVID pandemic in relation to cybercrime investigation and prosecution? So first, we assure the public that there's continuing cybercrime operations even during the period of public health emergency in the Philippines. More of this can be shared by Senior Agent Senora. I know that he has good and successful cybercrime operations for the past months. And also there is an increasing of online presence. So the NBI, the PNP, and our office, we have increased our online presence by activating, for example, our social media accounts where the public can ask questions regarding cybercrime and cyber-related cases. There is also strengthened interagency collaboration, fostering international cooperation, and we facilitate the the members of the criminal justice system to be kept abreast of the global landscape and response to cyber threats, and of course, raising public awareness. So that's my last slide. Thank you very much for your attention.
Thank you, Attorney Ange. Let me just, okay. Moving on to our next speaker. Our next speaker is Agent Francis Senora. Agent Francis Senora is a senior agent at the Cybercrime Division of the National Bureau of Investigation, or the NBI. He's a certified public accountant, an internal auditor, and he's a certified treasury professional, and also a certified ethical hacker. He has handled many investigations of cybercrimes such as cyber pornography, online sexual exploitation, cyber libel, and phishing. Agent Senora.
Thank you, sir.
Yes.
Good afternoon, everyone.
Yes.
Okay, I'm going to show a short presentation.
There you go.
Okay, how do this one? Nawawala yung aking ano. Dali lang.
I think you just need to start.
Yes.
Yeah.
Just have technical difficulty lang.
Yes.
Okay. Hello, good morning, everyone. I'm going to present what is the current cybercrime trends now in the Philippines. Okay, after this presentation, my goal is to provide everyone an idea on what is the current cybercrime trend, the prevalent cybercrime and the reason of increase, hindrances on investigation, the good part, and the future outlooks. So, what is the current trend? Okay, the current trend is going up. So, what does it mean? It means that the cyber threats are constantly evolving. Because they need to take advantage of the online behavior and the trends. And the current pandemic is no exception. The cyber criminals are actively attacking the computer networks, systems, individual businesses, and even global organizations at a time when everyone is shifting their focus from being a cyber savvy person, now being a health conscious person. What happens now with the recent pandemic? Now we have suddenly become reliant on services that allows us to work from home and learn from home. Likewise, we are now practicing social distancing. And as a result, we are now more on trend on a video application apps on conversing with everyone and messaging. So as of now, there's the rise of, for example, there's a rise of web seminars or webinars. Okay, the COVID-19 pandemic renders individual society extremely vulnerable in all aspects. As I mentioned earlier, everyone now is dependent on the internet, the way how we communicate, how we work, how we share our ideas. Everyone is tied up to the internet. So, what are the current cybercrime incidents for us as this COVID situation? Number one, we have the phishing, SIM swap, PPE scams, child porn, business email compromise, nuisance scammers, and perception wars. Okay. So number one, phishing. As you can see, I think there has been a strong growth of phishing threats for the past few months. Actually, the January we only have 5 to 10 cases, but as soon as the pandemic arises, this 5 to 10 cases rises to 30 to 60 and to hundreds. So imagine the percentage of increase. It's more than 200%. Why is that so? Well, I always talk about the COVID-19 pandemic as a phishing season. Bakit po? Well, more people are now inclined to work, to purchase, to transact online. Hence, yun po yung nagiging trend right now. I mean, as I mentioned earlier, people are now engaged on working on the internet. However, at this stage, opportunity threat actors or negative opportunists saw this chance to have have their financial gain. Hackers and fisher alike have enjoyed the season of pandemic. I mean, to get more victims. We always treat hackers and fisher as related because the action and intention are almost the same. It may not have been always financial gain, but at the end of the spectrum, they always need to prove or gain on something. So now, why are we having this trend right now? Because at the advent of the internet, international hackers and local-based foreign threat actors now has the capacity to share. There are a lot of foreign groups, foreign forums, chat groups, when they are allowed to share their ideas to everyone, and the opportunity increases because they're able to recruit people, foreigners and local people to act as their mule. Syempre, pag nang-hack sila, they want to separate themselves from the funds from the action that they have done. So to shield themselves from being caught, they would try to lure potential mules as a person to engage on the withdrawals, paano i-transfer yung pera. So they are now becoming more organized and syndicated. Okay, this is the common forms of phishing. First is as you can see, the social media phishing, where they try to create a fake website that looks like a legitimate social media website. But if you look carefully at the URL, it's very different. Like if you see the top part, it's Facebook. But if you see this one, the URL, it's different. So what is this? What is the aim of this phishing site? It's to collect Facebook data, your credential in accessing Facebook data, for them to have an access on your account. And again, once they have the access to your account, makukuha na nila yung gusto nilang makuha, and they would use it against you. Also, in the rise of this pandemic, we encountered a lot of bank phishing scams. So what are these? These are phishing scams done by hackers and fishers alike that uses a fake bank website that portrays almost genuine website. So pag hindi ka marunong tumingin ng website, you will be fooled. Nakala mo legitimate yung website na inaano mo, you're accessing. So at the time you access those websites, mabibigay mo yung bank credential details mo. So at the end of the day, when they have access to those, they can freely transfer funds or withdraw funds without your authorization. Another crime that increases during this pandemic is the online scams. As you can see, there are a lot of reports and a lot of actions by the law enforcement on this online fraud scams. Well, at the rise of this fraud scam, at the rise of this pandemic, nagkaroon ng increase of necessity sa mga masks, hand sanitizers, and medicine na nag-procure daw ng COVID-19. So, dumami yung mga opportunities on this one. Since alam nila na mayroong opportunity to earn, minsan ang ating the public unknowingly are becoming more vulnerable. Kasi nagmamadali tayong maka-purchase and we forget to check if we are indeed engaging on a legitimate person or a website. Third largest happening during this pandemic is the rise of fake news. As you can see, almost on the past few weeks and months, ang daming fake news na lumabas. One classic example is the fake news about a certain hospital, wherein they reported that there was a huge numbers of body bags that's been scattered along just the hallway of the hospitals. But through verification, we found out that the video was not here in the Philippines. Actually, it's situated abroad. So nagkaroon ng temporary panic and fear on the people. So again, ito yung mga nag-rise during the pandemic issue. Next is the misinformation and fake news spread by troll and fake media accounts. This is the ongoing trend right now. Everyone is entitled to create their own social media accounts. However, there are issues that need to be tackled. Unfortunately, at this point, anyone anonymously can create an account, and anyone can create multiple accounts. So ito yung nag-give rise dun sa mga trolls and opportunists, because they see now as a social media as a very powerful tool. You can convince a person. You can create a fear. You can create fake news. Actually, that is what we call right now as perception wars. In the advent of pandemic, the coming elections, everyone is trying to mold the minds and individual to a certain point that they would like for their own advantage. So ngayon, we are expecting to the rise of troll account. However, as countermeasure, the law enforcement, NBI, and PNP alike, we are always coordinating with the social media website on what are the internal controls in so far as to this troll accounts. The troll accounts would be there, but again, there's always going to be an action on it, and we are always coordinating with the social media websites such as Facebook on what are the aspects, what are the trends, so that here on our country we could have a device that would allow us to report and to take notice and to take the important details of this fake social media accounts. Example of fake social media accounts. Well, as you can see, during the past few days, past few weeks, there were death threats to the president. There were a lot of trolls doing this negative information. So again, there is a problem on this social media trolls. Why such things are pretty prevalent? Again and again, as I always mention, the current internet was introduced to the people as a form of way to have fun. Hence, the internet EQ and IQ natin is started on a low level. Internet was not shared to us as a form of education or a form of research. It was introduced as a form of entertainment. But the shift and focus right now of the government, along with the different institutions, we're trying to introduce the internet EQ and IQ. Okay. Again, I know every one of us has been we know some people who have been engaged in cybercrime, have been a victim or have been attacked by cyber criminals. There are issues that we have raised earlier during the presentation of the Argo Justice and spokesperson from DOJ. Okay, as a law enforcement officer, we have also day to day we have met this hindrances. One of it is jurisdiction issues. As you can see, social medias, their servers are located outside of the Philippines. Hence, accessibility on information whenever we need it are sometimes hampered. We have to take on consideration the help from DOJ and ask through MLAT that if we need something coming from a foreign company which is situated outside the Philippines. Another issue is the complexity of cyber issues and its ever-growing trends. For example, sa phishing, we have already deciphered some of the codes they use when they do phishing on social media site and bank websites. However, again, hackers have more time on the marami silang oras to innovate. Kasi nga, yun lang yung ginagawa nila. So again, it's important for us law enforcers to have this day-to-day appraisal and growth on how we handle this cyber issues. Next, and the most popular one, is difficulty of gathering evidences. You know, this now you see it, now you don't. Yung mga posts natin sa internet, yung ephemeral nature nila, sometimes nakita natin yan ngayon, mamaya madi-delete. So we're having trouble on presenting it to court. Because sometimes we could not prove something when we don't have a proper evidence to show that it exists. Yun ang nagiging problema natin. Sometimes yung mga posts, videos, they can be easily deleted. We can do, we advise the people take some step, but again, day-to-day, sometimes pupunta yung tao sa amin na meron pong posting na ganito. Then pag meron pong parang libelous statement against me. But when we check it on the internet, at a few minutes after that, wala na yung post. So nagkakaroon ng problema if we're going to present sa court yung existence ng account. Okay, ano ba yung ginagawa namin on how to fight those hindrances? Number one is properly preserve electronic evidence. Okay, when you do a screenshot, make as much as possible, yung screenshot contains the URL. For example, in Facebook, nandun yung www.facebook.com. Why? At least mapuprove natin yung existence ng post. Law enforcement such as NBI and PNP, we have this access to Facebook called law enforcement page, wherein pag merong very urgent na cybercrime, nabibigyan naman kami ng tulong. For example, merong terrorism attack, child pornography, or imminent harm or death, we could easily get that from Facebook as long that you have a proper preserved electronic evidence or screenshot containing the offense and the URL of it. Likewise, we also need during presentation of evidence in a court hearing is the image copy of the needed computer data. Yan, mami, dyan nag-rise yung mga warrant kanina as discussed by the good justice and Angeline from DOJ. There's whenever we go to court, we need to have a credible copy of what is contained on a computer device. We don't use the computer device itself, but we only use the credible copy of that device or exact copy. Pag diniscuss natin, mas mahaba pa yun. But again, what ang pinipresent namin sa court is the exact copy of what is inside a computer device. Yung computer device na yun will undergo a digital forensic examination. There we get, again, number 3, logs and lot of computer logs. There we study the logs, tingnan namin kung ano ba yung access na nangyari doon, what happened there, sino ang, at what point siya nagkaroon ng compromise, at what point nag-exist yung illegal computer data. Yun yung silbi ng logs. And then after that, we will have a digital forensic result. This will have an background on everything that happens as we complied all the logs that we get and all the images that we get. At the time that we get these forensic reports, we will also get support from associated agencies and institutions. Ano ba yan? At that time, we seek their help to authenticate yung mga result namin. There are instances namin nakuha kaming digital evidence, and we need them to help us to explain those digital evidences. Okay, despite of all the current situation, the increase of these technicalities, I always call this the rise of cyber friends. Okay, what are these cyber friends? This is the people from different walks of life now understanding that there's a need to reevaluate and to enhance the current cybercrime tackling issues. So ngayon, there is as discussed earlier, there are type of cybercrime warrant. However, as our practice, we only use the 3 warrants: warrant to seize and secure examine computer data, warrant to examine computer data, warrant to disclose computer data. So again, on the practicality side, what are the difference of these 3 warrants? As to warrant to seize and secure examine computer data, this is the type of warrant when we applied when the device is not yet on our possession. Yun nga, so magkakaroon ka pa ng actual raid, magkakaroon ka ng actual possession taking ng iyong warrant. So we go to court with our affidavit and the complainant and the pieces of evidence we required, and we apply this warrant. And pag nag-grant kami, isi-serve namin yung warrant, we will seize the computer device, and we will do forensic examination. There are two types of forensic examination. There's a on-site and off-site. Sa on-site kasi, if it's possible, we will do the imaging and the analysis on-site. Halimbawa, masyadong maliit lang naman yung computer data, it's a few gigabyte, we will use our portable tools to do the examination. However, kung isi-seize namin is hundreds of hard disks, hard drives, what we'll do is that we will get those hard drives and bring them to our digital forensic lab. Okay. The second type of warrant is warrant to examine computer data. Ito naman, we use this on devices that already at our possession. Ano ba yan? For example, this is devices that we seize during warrantless arrest. For example, may entrapment. During the entrapment, sinis namin yung kanyang phone. Again, as explained earlier, hindi naman namin pwedeng buksan yon. So what we do, we apply a warrant to examine computer data to a court for us to have an authority to open the said device and examine the contents of it. So pag nakuha namin yung contents niyan to digital forensic, we will then submit it to court as part of our evidence. Another commonly used type of warrant is warrant to disclose computer data. This is a type of warrant that orders an institution or individual to disclose a computer data on their system. Most of the times we use this warrant sa mga telcos. Halimbawa, in a case there is a need for an information regarding this subscriber IP, so ito yung ina-apply namin sa court. So we are asking the court to grant us an authority to order someone to provide us logs of that IP. We also use this on the request we made on social media companies such as Facebook. But again, this warrant is served together with the authority coming from the Office of the Cybercrime of DOJ. In addition, pag nag-a-apply kami ng warrant, it always is supported by the affidavit of the law enforcement agency, the complainant, and the pieces of evidence acquired or available. Again, with all of this, at the end of the day, it's going how we stop cybercrime, how we control it, and we could not stop it 100%, but we aim to control. We aim to control it on a reasonable level. So how do we control it? It starts from the grassroots. I always do believe that internet culture is important when we tackle or fight cybercrime. Kasi kailangan natin na matutunan on a deep down level na this is something different. We should not do this. If the people have this high internet culture, madali nilang gawin kung ano yung mga internet etiquette. For example, backing up online and offline regularly, strengthening your home network, use your strong password, keep software updated. You control what you shared in the internet. As long as you have a proper internet culture, yung cyber safety check is very easy. Again, at the outlook, as I end this presentation, everyone needs to be extra cautious, especially the security measures on cybercrime. Likewise, intercultural awareness enhancement is always necessary. And a nationwide campaign on the proper internet usage be disseminated not only on the government level, but also on the public sector. Hand-in-hand interaction between the government and the public is necessary. Hindi po namin kaya itong mag-isa lang. So as much as we wish, we always hope that there is a cooperation between public people, the public sector, to share information to the government. Yan kasi we do have problems on that kasi sometimes public individuals, even though they are victimized by cybercrime, they don't report it because they take it as a nuisance. But again, it is important for us to have those data kasi on those data, hindi natin alam, doon natin malalaman yung mga incident na how we could catch those cyber criminals. Thank you very much po.
Thank you very much, Agent Senora. So before we go to our Q&A, I'd like to share something first with you for our attendees. Oh wait, hold on. Hold on, let me stop. I think I made a mistake. I'll do that again. Yan ang hirap pag ang gumagawa ay share computer. Okay, here we go. So as you can see, that's Shorts. That's a project that we are supporting here at Digital Transformation Thursdays. You can learn more about Shorts by visiting their site. I'm showing it to you now. This is on shorts.ph. On August 20, they're going to be having an event. The theme of the night will be lockdown. We're calling people, anyone, if you want to join in, submit a topic. Talk about it for 8 minutes. We did our first event before. These are, if you'd like to visit and talk about the story, see the stories that were told before. The theme of the first Shorts was ang mamatay ng dahil sa'yo. The theme on August 20 is lockdown. So we hope you can join us for that. And if you're so minded, you can join us and submit a topic and speak there as well. So I'd like to invite my fellow speakers to turn on their cams and let me see. I should make it na. And we'll go to the Q&A. Okay. I don't know. Hold on. I'm trying to figure out if what the view is. Okay. So siguro. Hold on. What is the first question? First of all, thank you very much for there you go, for presenting. So all of us now can be seen. Okay. So siguro the first question kay Justice. Ang dami po questions, no? Tinanong, one question, Justice, is can online cloud services may be included in the search despite privacy clauses in those terms? Justice, nakamute kayo, Justice.
Again, Ken?
The question is cloud provider, sakali Amazon, can a search warrant be directed at them?
Well, it depends on what the crime is. If yung respondent, ganun lang naman eh. Look at the respondent if the respondent is probably guilty of the crime that is charged.
That's right. That's right. So long as you include that in the in the.
You go back to the basics always.
That's right. That's right. Okay. There's a question on. Hold on. What if a mobile phone was seized after an arrest? Is a warrant to examine on the phone still required? And if the data was searched without a warrant, would it be considered fruit of a poisonous tree before presentation in court? That's from Muriel Panganiban.
Wasn't that like my query?
Oh, it's very similar, no?
No, it was a warrantless seizure. And then, like I said, you cannot proceed to the next level of opening the mobile phone. You need a warrant to examine. But I saw a similar question.
Okay.
Do you need another warrant? I think it's in the search of the pornography. Do you need another warrant to search, seize, and examine? Or can you jump to a warrant to examine?
Oh, that's interesting. I think the answer is warrant to examine, right? Because it's already in your possession.
That's right.
It's already in possession. But I mean, that was a very good question to ask, Justice, because some people think that just because, I mean, and this is really one of, there was a question, I think it was posted on Facebook. You know, the concern of many people is that when a warrant is issued, the warrant, you know, and Agent Senora can confirm this, when you search a computer, you get the entire hard drive. And that is what you will image. So now they're concerned, not everything in the hard drive is relevant to the search.
Right.
Or to the search warrant. So I think that's the value of that question, Justice. That the way you're supposed to do the search warrant is it will
Just
delimit
limit yourself to the crime that is.
yes, the object of the crime. Ano. And if you find something else, like actually napaka-controversial po ng example nyo, Justice, which is child pornography, because that is contraband.
Yes.
And so, and that's why that actually makes the question more compelling.
Plain view doctrine, di ba?
Yes, well, plain view. But I think the one way of looking at it is that the fact that, because, you know, if you accidentally chance upon it, the image, the child pornography, that is now your basis for probable cause. When you go back to apply for the warrant to examine, you say probable cause was because we were doing this search and we stumbled upon this and we want to do a search for more evidence.
And may I raise one thing more, JJ? Of course, we reviewed the US jurisprudence on this now, and they're quite divided. But more jurisprudence would say that you apply for another warrant to search. However, we are different in our jurisdiction because we have the warrant to examine, which they do not have. Right? So we can actually skip in some instances. You don't anymore need another warrant to search because moot na, diba? It's already with you. Eh? Search and seize. Because the officers already have the data. So the next step na lang, warrant to examine.
That's right.
You get the difference because in the US, they have to apply for another search warrant.
Okay. Actually, interesting story. There was a case where a mobile phone was seized, and it's now in the possession of the law enforcement agents. And one of the crime involved a website, and you have to buy something on that website. And there was a phone number listed on the website. So what the complainant did was they dialed the number on the website, and lo and behold, the phone that was seized from the perpetrator when he was arrested, that phone rang. So suddenly now there's a link. But again, same situation. The item was seized pursuant to the arrest, but now now it has to now you need a warrant to examine, right? To say that is the phone number for that phone. I think there's an agent there's a question for Agent Senora. Is there a way for us lawyers to trace on our own if a certain account is a troll or fake?
Well, good afternoon. Unfortunately, access to Facebook law, I mean to this social law enforcement pages are limited to us law enforcement. So again, well, aside from regular checking or we call technical surveillance, where you review the account, the posts, and the location of the post, kasi meron yan nakalagay, di ba? Sa mga post mo, minsan kung saan mo pinagi. However, if you're going to a more specific details, we need to ask the assistance of these websites. And what we do is that we use their portals and we ask the assistance of Office of the Cybercrime of the DOJ to get these results.
All right, thank you. There's a question here about online gender-based violence or harassment. For example, through the spread of sensitive photographs in a chat group or through harassment on social media has increased in volume during the lockdown. I'm directing this question to Attorney Ange. Do you know of any actual prosecution of gender-based violence or harassment in relation to, say, the Safe Spaces Act? Attorney Ange.
Yes, sir. Actually, there is we don't have any yet in the database of the Office of Cybercrime regarding any prosecution under the Safe Spaces Act. It's because siguro hindi pa na i-report sa Office of Cybercrime. But what I can share is that under the Safe Spaces Act, the primary law enforcement authority task for its investigation is the PNP Anti-Cybercrime Group. And recently, the IRR was passed, and now the DOJ OOC is currently leading the technical working group composed of prosecutors and investigators in developing the guidelines in case build-up and prosecution of these types of cases. But of course, since these are online gender-based harassment, the same procedures when conducting cybercrime investigations will be conducted since the crime was committed online. So we would still apply the preservation, cybercrime warrants, and international cooperation mechanisms under the 10175.
And here's a very important question. If the perpetrator of the cybercrime is unknown, how do we begin to investigate that? Maybe first come on kay Agent Senora. So I go up to you, I say, I don't know who's doing this to me. All I have is a Facebook account.
So again, okay, sir. It's important to note what is the cyber offense are we talking about?
Let's say harassment, safe spaces, gender-based.
Kung gender-based, so it's important that we prove again na may yung allegations niya na meron ng harassment na nangyayari. So it's important that they have this screenshot and the soft copy of the screenshot with them. Okay. It's also important that when you made the screenshot, it has this necessary details on the screenshot. Number one, you have the harassment, you have the account, you have the URL. The URL or in a common term is the internet address. It's very crucial when we do investigation. Why? Kasi yan yung parang fingerprint ng account. Most of the times, the URL cannot be changed. So yan yung pinaka-importante sa aming law enforcement is to have those data for us to verify if indeed totoo ba yung post na to. Kasi minsan someone is submitting a malicious complaint. So before we do the actual investigation, the request, the technical surveillance, we need first to determine if indeed yung sinasabi niya account that commit the harassment is existing or not. Kahit na-delete na kasi yan sa cyberspace, as long as you have this URL, we have ways. Siyempre, I will not tell you about that, how we do that, but we have ways on determining if indeed such account have existed in the internet.
Okay.
Siguro,
I'll push you a little there. If you have a phone number, for example, if it's Facebook, and you know there's free Facebook now on
yes, sir.
on Globe and Smart. So then, would it make sense for the NBI to apply for a warrant to disclose information directed at the telcos to try to provide any information they may have about this user account? Would they have that info? Kaya is it possible?
Okay, sir. Parang cross-examination na. So again, if we're talking about the account, sir, it's important that if we would link na meron talagang link yung number na to sa account. So we have a process on how we do that. So siguro we done the process and then we determine that this number is again related to this subject Facebook account we're talking about. So first we verify if there's really an offense. Diba? Kung napatunayan naman natin that there's an offense, we would ask our complainant to execute an affidavit regarding that offense and the relationship of that number to that Facebook account, and we would apply a warrant to disclose computer data on the court, on the cyber court, and whenever we have those data, we would present it to that telco, for example, Globe and Smart.
Sir, if I could add something on that. Yes. So I'll just walk you through what would happen kung sakaling nag-file ka ng case violation of Safe Spaces Act, for example. So you would file your case with the PNP ACG, and if the harassing comment was posted in Facebook, PNP ACG would issue a preservation order to Facebook to preserve the records pertaining to that account na nag-post nung harassing comment. And then the PNP-ACG would now go to our courts and tell our courts na there is this crime committed, napapreserve na namin yung computer data with Facebook. Can you please give us or issue us a warrant for the disclosure of the computer data? And that warrant for the disclosure of computer data na i-issue naman ng ating courts would be coursed through the DOJ OOC, and ibibigay natin sa Facebook. And then si Facebook, ibibigay niya yung information regarding that anonymous Facebook account. And maybe from that anonymous the information coming from Facebook, nakalagay doon ano yung IP address ng person na nag-post, ano yung number na ginamit niya. And from that, ipapapreserve naman ni PNP ACG yung records sa ating mga telcos. So si ACG would go to our telcos, can you preserve the information regarding this IP address and regarding this number? And then after preservation, balik na naman si ACG to our cybercrime courts and please issue us a warrant for the disclosure of computer data. And then we have the electronic we'll have the electronic evidence that would be a basis or that would further the investigation of such crime. So parang ganon, magiging ganon yung ikot ng ating investigation in such cybercrime cases.
Okay. I think there's a question here. Actually, my question kay Agent Senora about when they're surfing daw and the account says HTTPS, tapos may padlock, does that mean that the site is authentic?
Well, there are many forms to authenticate a website. So one of which is those yung meron ng padlock. Kasi yung HTTPS, yung S na sinasabi na secured yung website. Actually, yung authenticity is not on HTTPS does not mean na authentic yung website. It just means na yung secured yung website. But again, one of the characteristic of a secured website, of a authentic website, is secured siya. So it's important that we also take note of that. Likewise, yung mga authenticity niyan, may mga other forms of checking pa yan. Normally, syempre, kung ang isang, for example, is transacting to a bank, kung Philippine bank yan, dapat ang end ng kanyang website, kung ano ba, .com.ph. So dapat PH yan, Philippines yan. If you're transacting na sabi nga, halimbawa, is a local bank, pero may .jpn. So may problema na yan. So why is that, ano ba yung .jpn? Ibig sabihin sa Japan-based yung bank when you're transacting to a local bank. Marami pong procedures on how to do that. But again, one of those which is yung tine-check natin yung HTTPS web, yung kung may secured nga yung website.
Okay. Actually, there's a... okay na. Let's see. The guidelines about remedy, another remedy, the chain of custody is broken without fault on the part of the party. How can prevent causing prejudice to the case? So chain of custody would be, Agent Senora, dun sa inyo, it's more of your the fact na na-seize nyo yung item and it's continuously in your possession.
Yes, sir. Or kung make order na kami from the court, is from our possession, it is delivered to the digital forensic laboratory.
All right. Attorney Ange, how hard is it to get evidence from this foreign provider, say Facebook or using the mutual legal assistance treaty process of the DOJ?
In answering that question, sir, we should distinguish what type of crimes are we investigating? So let's distinguish, like for example, if we are investigating an online child sexual exploitation or human trafficking case, kapag ang hinihingi natin na electronic evidence from these foreign electronic service providers relates to these types of crimes, mabilis lang. As long as we have a warrant coming from the courts na preserve natin yung data with our the foreign company, once we serve them the warrant, ibinibigay nila agad because it's their policy that if these are the types of crimes, mabilis agad yung kanilang response. But if we are so we call that informal international cooperation, mabilis makuha, and hindi natin pwedeng sabihin na kahit informal international cooperation is hindi safeguarded yung rights because ini-release pa rin nila yung data by virtue of a warrant. So protected pa din yung privacy, or we know that it's based on a legal order. But if we are investigating a more traditional crimes, ito hindi kaya ng informal international cooperation. Kadalasan talaga idadaan natin sa mutual legal assistance, which may take a year to 2 years. So we should distinguish kung anong crime yung iniimbestigahan.
All right. Thank you. So ano na lang, perhaps if I could just ask our speakers if you have some closing statements that you'd like to for our viewers. We're last 2 minutes. We'll start with let's have the ladies have the last word. So maybe una muna si Agent Senora.
Okay. Again, and then I just want everyone to always understand na yung internet culture. Yan lang lagi kong sinasabi. Internet culture. It's important for us to have that. Kasi kahit anong sophisticated website we have thousands of webinars. We have this pamphlets. We have these schools running about that. It's important for us to understand how to use the internet first. It's important for us to have to embed internet culture starting from the minds of the young. Kasi as they understand na ito malito sa internet, this should not be done, they should stay away from this. Pag at early age, alam na nila yan. At the end of the day, it's going to be easy for us, government agencies and private agencies to combat cybercrime. Thank you.
Thank you. Thank you. Attorney Ange?
Yes, for me, I would just like to highlight the importance of immediate reporting of a cybercrime incident to law enforcement authorities, especially if we are after asset recovery and following the money trail. Kasi kapag when we are investigating, like for example, online fraud at ang tagal na, 1 month na or 2 months na bago mo ni-refer yan sa law enforcement authority, kadalasan yung the digital evidence, the electronic evidence na kailangan natin, wala na. Kasi yung iba wala namang obligation to preserve these types of electronic evidence. So it would hamper our asset recovery and the investigation of cybercrime. So please, if you know about a cybercrime incident, report it agad sa ating law enforcement authorities, the NBI and the PNP.
And finally, Justice San Pedro.
Thank you again, JJ. I'd like to emphasize 2 things. Number 1, education and training. And I'm glad that from the beginning of our efforts to train our judges, we've had this synergy with the PNP and the NBI, because it's important. That brings me to my second point, that we should have a joint goal, which is to eradicate cybercrime. And unlike before, na nagkakaproblema ang NBI, PNP at courts, ngayon it's good to know that we are all working together to cooperate, not to cooperate in a way that will be bad for the accused, but to cooperate in such a way that we all have the common goal of battling cybercrime. So I hope that we will continue to have this cooperation, synergy, together with practitioners, because we need to know what is needed by the practitioners, what is needed by those who want to file cases, so that we will also be responsive to those needs. Thank you, JJ.
Thank you, Justice. Once more, thank you to all our speakers. We're very happy that you were here. This is our most successful Digital Transformation Thursday. Most number of registrants, most number of attendees. We're I'd like to thank you again. I'd like to formally close this. I'm going to share just a promotional, let me see, a video for shorts. And thank you very much.